Before starting argument in a case, a junior advocate or even a senior advocate must decide what to argue and what not to argue, what facts to place before the judge, what facts not to place before the judge, what legal points to argue and what legal points not to argue. At the same time, if you suppress important facts, important provisions of law, important case laws, judge may even accuse you of misleading the court. In this video, you will learn how to make the right choice about what to argue and what not to argue. Before starting argument in a case, a lawyer has to decide a very difficult question: what not to argue and what should be argued. You should not start argument without preparing a well thought out plan of argument beforehand. All senior and all top lawyers do this, though they may not acknowledge it in public. Many lawyers prepare facts and law and then go to court without first deciding what to argue and what not to argue. They plan to decide this on the spot after seeing the reaction of the judge and of the other side. In my humble submission, this is not the correct strategy. The right approach is that before going to the court, you must decide what to argue and what not to argue. But this is not rigid, this is not inflexible. Depending on the reaction of the judge, depending on the argument of the other side, you have to make changes in your already prepared plan of argument. You should, or rather you must, start your argument by placing your most important, most worthy point. You must try to bring the judge in your favor from the very beginning. The lawyer's attempt to persuade the judge in his favor starts from the very first sentence a lawyer appears during his argument. A lawyer must try to see that the judge starts saying yes, yes to his initial argument. If on the other hand, the lawyer starts with a doubtful point, judge will start saying no, no from the very beginning. And when you start placing your best argument towards the end, the judge will be in a negative mood, in a negative mind frame, and may not be in a mind to appreciate your best point which you kept reserved till the end. The facts in a case may be contained in hundreds of pages or even more than 1,000 pages. You don't have time to place all the facts before the judge. Judge will also not allow you to place all the facts. You will be allowed only a limited time to argue your case. The argument that you make during the first 5 or 10 minutes of your argument will generally decide whether you will win the case or you will lose the case. Before going to the court, you must study the facts very, very thoroughly, analyze the facts to decide what facts are in your favor and what facts are against you. Give more importance to the facts against you and think of possible and convincing replies to them. But do not suppress important facts against your client. Otherwise, judge will accuse you of misleading the court. Place the facts against you before a judge with a plan. Place them in such a way that they do not prejudice the judge against you very much, and place these facts with convincing explanations for the same. Before placing provisions of law, thoroughly study them and analyze them. Think of the possible questions that may be asked by the judge. Think of the possible argument that may be made by the other side. Prepare convincing replies to such questions or arguments beforehand. Otherwise, you will not be able to give convincing replies to such questions or arguments, and you may lose the case if you have not decided possible replies to them beforehand. Regarding case laws, try to find out latest case laws which may not even be reported in law journals. You must be sure that the case laws applies to the facts of your case. Remember that the other side will try to argue that on facts that particular case is distinguishable from your facts. Unless you have studied the case law very, very thoroughly, you will not be able to answer the question of the other side that the facts of the two cases are different. So, my friend, you must not start argument without thorough preparation. You must decide beforehand what to argue and what not to argue.